Check. Good evening, Honorable Attorney General, President's Councils, distinguished invitees, well-wishers, and competitors. Welcome to the closing ceremony of the 9th H.V. Pereira Queen's Council Memorial International Moot, hosted by the Moot Society of Sri Lanka Law College. On behalf of the Moot Society, thank you all for gracing us with your presence. We now invite all of our guests to join us for high tea as we prepare to begin this evening's proceedings. Thank you. Check. Good evening, Honorable Attorney General, President's Council, distinguished invitees, guests, well-wishers, and participants. Welcome to the closing ceremony of the 9th H.V. Pereira QC Memorial International Moot, hosted by the Moot Society of Sri Lanka Law College. This competition began as an idea that Sri Lanka could give the world of arbitration a platform of its own. And today, looking out at every team in this room, that idea is very much alive. For the 9th year running, we have made it our mission to gather the finest young legal minds and give them one stage to argue, disagree well, and to grow. In Sri Lankan tradition, we begin occasions of significance by invoking light and wisdom. To begin today's proceedings, may I have the pleasure of inviting our chief guest, Honorable Parinder Ranasinghe Jr., President's Counsel, Attorney General of the Democratic Socialist Republic of Sri Lanka, to light the traditional oil lamp and mark the beginning of this celebration, followed by Dr. K. Kanagiswaran, President's Counsel, Ms. Indira Samarasinghe, President's Counsel, former Principal of Sri Lanka Law College, Mr. Prasantalal Dialwis, President's Counsel, Principal of Sri Lanka Law College, Mr. Chanaka De Silva, President's Counsel, Mr. Upul Jayasuriya, President's Counsel, Mr. Rajiv Amarasuriya, President of the Bar Association of Sri Lanka, Mr. Nalin De Silva, Secretary of the Bar Association of Sri Lanka, Mr. R. Shehansi Pereira, Deputy Principal of Sri Lanka Law College, Mr. Vinura Gamage, President of the Moot Society of Sri Lanka Law College, Ms. Indivari De Silva, Chairperson of the 9th Victors Moot. Please rise from your seats as a mark of respect. Thank you very much, ladies and gentlemen. Please remain standing for the Sri Lanka Law College anthem. Thank you, ladies and gentlemen. You may now be seated. It gives us great pleasure to invite a gentleman whose guidance and vision continues to steer this institution towards excellence. The Principal of Sri Lanka Law College, Mr. Prasantha Lal Dialvis, President's Council, to deliver the welcome address.
Good evening. Ayubowan, Vanakkam, Assalamu alaikum. Ladies and gentlemen, it's my humble task, privileged task, to welcome all of you to our signature project of Sri Lanka Law College. This 9th Moot is historical. It rewrites legacy of Sri Lanka Law College, and it creates vision for the future. Why I say this, ladies and gentlemen, Sri Lanka Law College came into existence in 1874, exactly 152 years ago, only 4 years younger to the Medical College of Sri Lanka. We have such a long history. That was the year where two oldest universities, Vidyalankara and Vidyodaya, came into being. So, we Sri Lanka Law College has a proud legacy to strengthen and to behold and to take it for the future. That is the task of Sri Lanka Law College. Why this Moot Society is critical and important for this legacy to be rewritten is because it is what we are. Mooting is all about being a lawyer. Section 40 of the Judicature Act creates a lawyer who is competent in knowledge and with ability and repute. That is what Sri Lanka Law College is supposed to be. The Moot Society creates such a person with ability and repute, in addition to having a competent knowledge. Ladies and gentlemen, these victors Moot symbolize a very interesting, unique scenario. We Sri Lanka Law College term our students as warriors and gladiators. Our warriors and gladiators of Sri Lanka Law College, when you talk of this, organizing this event, myself and Shehan, we only give our signature to give permission and just to motivate them. It is they who find the money. It is they who organize things. It is they who coordinate. It is they who execute this. So Sri Lanka Law College salute you, Vinura, Indivari, and the whole team for making this happen and making Sri Lanka Law College very proud. Ladies and gentlemen, on behalf of Sri Lanka Law College, I welcome all of you. Honorable Attorney General, sir. You have been always with Sri Lanka Law College. You have almost become a part of us. Every function, you make a point to come with your busy schedule. Thank you and welcome you for this occasion. Mr. Kanagishwaran, you gave us the moot court. If not for you, we will not have a moot court. So your presence gives us huge strength. And other former principals, representatives of the Bar Association, our adjudicators give us absolute strength. So ladies and gentlemen, on behalf of Sri Lanka Law College, I welcome all of you. We shall rewrite the legacy tonight and establish our mark as the pioneering legal education institution in Sri Lanka. All the best. Have a nice evening. Thank you.
For centuries, civilizations have looked to the sea as a gateway to prosperity. Coastlines have been transformed into cities. Harbors have evolved into gateways connecting nations. Land has been reclaimed in pursuit of progress, opportunity, and national growth. Yet, the pursuit of progress has always demanded a delicate balance between economic ambition, environmental responsibility, and public interest. In an increasingly interconnected world, these challenges have transcended borders, requiring solutions founded upon justice and the rule of law. As international commerce continues to evolve beyond boundaries, so too must the mechanisms through which disputes are resolved. International commercial arbitration has emerged as a defining force in modern dispute resolution, providing a trusted forum where legal principles and international cooperation converge. It is now upon the next generation of legal professionals to understand, advance, and carry this tradition forward. We can transcend boundaries, explore the complexities of global commerce, and shape the future of international dispute resolution. We can inspire a generation of advocates who stand firm in integrity, reason, and the pursuit of justice. And to bring this vision to life, the Moot Society of Sri Lanka Law College proudly presents the 9th H.V. Pereira QC Memorial International Commercial Arbitration Moot Competition.
The H.V. Pereira QC Memorial International Moot Competition has been the first international commercial arbitration competition in Sri Lanka. This year, for the 9th edition of the Victor's Moot, we'll be having it hybrid after 6 years since 2019, since we had a physical moot. We had an extremely competitive preliminary rounds with 8 teams, 2 from Singapore, 3 from India, 1 from South Africa, and 2 teams from Sri Lanka that broke through to the quarter-final rounds that are taking place physically in Sri Lanka for the 9th edition of the H.V. Pereira QC Memorial International Moot Competition. The moot problem this year is based on land reclamation project and strategic foreign investments. We believe this is a pertinent and important point or area of discussion in the field of arbitration. We saw extremely good discussions and arguments brought out by the teams, and we look forward to seeing them grow in their future arbitration competition. We hope this competition allowed our participants to grow and gain experience in the mooting and arbitration field. I would like to thank everyone who helped us grow and helped us to make this 9th edition of the H.V. Pereira QC Memorial International Moot Competition a success.
Through this experience, we hope every participant leaves with a deeper appreciation of arbitration and the skills required to excel in an increasingly interconnected legal profession. Today, that journey reaches its culmination. A celebration of dedication, a celebration of advocacy, a celebration of excellence. Welcome to the closing ceremony of the 9th H.V. Pereira QC Memorial International Commercial Arbitration Moot Competition.
Thank you. We now move to a discussion of great relevance to the world of international commercial arbitration. A conversation on arbitration in troubled trade routes. We are privileged to welcome an exceptional panel to the stage. Mr. Chanaka De Silva, President's Counsel, Ms. Shahida Bari, Attorney at Law, Dr. Peshan Gunaratna, Attorney at Law, who will share their insights on this pressing subject. Guiding this discussion as our moderator, we welcome Mr. Minul Mohandiramge, attorney at law. Mr. Mohandiramge is a junior counsel attached to the chambers of Mr. Harith Dimel, with a practice focused on civil and commercial litigation, and a particular specialism in commercial arbitration and construction disputes. A Shivning scholar, he completed his master's degree in comparative and international dispute resolution at Queen Mary University of London, graduating with distinction and at the top of his class. He has coached Moot teams across Sri Lanka, Kazakhstan, and the Middle East, and we are fortunate to have his expertise guiding us this evening. Please join me in welcoming our panel on stage. Mr. Mohandiramge, the floor is yours.
Now, when I sat here in the table, I realized my arbitration journey actually started right here at the very first Victor's Moot. I was a finalist that year back in 2018. Even then, Dr. Kanagiswaran, who's sitting in this table, was one of the arbitrators. Unfortunately, the other two arbitrators are not here. Then I realized Victor's Moot, at least for me, was a starting point of my career in terms of what area of practice I really wanted to sort of focus on. This sort of continued down the line later on. And I'm sure for most of these participants today also, it'll be a starting point or at least a turning point in your practice, or at least something you will fondly remember from the time you spent mooting with your fellow teammates. Now, I have a very difficult task to do today. That is introducing a panel of speakers who've reached quite a height in their careers as well as in the field of law they specialize in, both academically and also in practice. But I will try my best. The first panelist is Dr. Peshan Rajendra Gunaratna. I have to use the support of my documents because they cannot. There is too much information in these bios for me to keep in mind. So much has been done. Our first panelist is Dr. Peshan Rajendra Gunaratna, a state counsel attached to the Court of Appeal unit of the Attorney General's Department of Sri Lanka, with more than a decade of experience at the official bar, and he's also an adjunct fellow at the East-West Center of the United States of America. Dr. Gunaratna is actually right at home here, because he's also the chief examiner and lecturer in international law at the Sri Lanka Law College. He previously served as a visiting lecturer in international security and international law at the Department of International Relations of University of Colombo. He was a Fulbright scholar for the year 2024-2025, where he conducted research at the Staten University College of Law in Florida on anti-terrorism laws of the United States of Sri Lanka. Dr. Gunaratna, interestingly, has a PhD in from University of Colombo, double masters in international relations, international business and finance, and to top that, he has a double bachelor's, one on international relations and a bachelor's in law. As I said, academically extremely well versed. At the moment, he has actually delivered guest lectures all around the world, including Hawaii Pacific University of United States, Army War College, the University of Colombo, the Bandaranaike Center for International Studies, as well as the Bandaranaike Diplomatic Training Institute and the Regional Center for Strategic Studies. He brings both the practical knowledge of being an Attorney General, being part of the Attorney General's department, as an advisor for the various government entities, as well as his academic prowess to the discussion table today. It is my pleasure to invite Dr. Prashant Rajendra Gunaratne as his first panelist for the evening. The second panelist for the evening is Ms. Shahida Bari, Attorney at Law. She is an Attorney at Law of Sri Lanka, as well as a Barrister of Law of England and Wales, attached to the Gray's Inn, and a member of the Chartered Institute of Arbitrators of the United Kingdom. She has been in practice for over 25 years, both in the private sector as well as in the official bar. At present, she heads her own law chamber where she consistently works in complex commercial litigations, arbitrations, and commercial disputes, and she works with several senior presidents' councils in this area. She also serves as a board of directors of the Personal Data Protection Authority, which was recently set up in Sri Lanka, as well as the Union Bank of Colombo. Before entering the private practice, she has served in the Attorney General's department for nearly 22 years, until she retired as a Deputy Solicitor General from the department. During her tenure, she represented and advised the government of Sri Lanka, public corporations, and various other government institutes on different areas of law. She has also served as a legal advisor for the Central Bank of Sri Lanka, as well as the Securities Exchange Commission, and was a member of the Law Advisory Commission of Sri Lanka. She has also advised various international organizations, including the World Bank, Asian Development Bank, United Nations Development Program, as well as USAID. Now, a little bit about her academics, which I think is my favorite part. She holds a LLB with a first-class honors from the London School of Economics and Political Science, a Bachelor's of Civil Law from University of Oxford, and an LLM in International Legal Studies specializing in business law from the American University of Washington College, where she graduated summa cum laude, and she's also a recipient of both the Commonwealth Scholarship as well as the Hubert H. Humphrey Fellowship by the Fulbright's Commission. Again, an individual who has seen how the world works, who has experienced what it means to advise the government sector, the public sector, and the stakeholders, and also with an equally outstanding academic backing. It is an honor to invite you on stage, Ms. Shahida Bari. The next panelist I'm going to invite is almost a household name in the arbitration circles in Sri Lanka. So you don't really need an introduction, but nonetheless, it's my duty. The third panelist is President's Counsel Chanaka D'Souza. He was called to the bar in 1986. He has been in practice for nearly 40 years. He is considered one of the leading legal experts in project finance transactions and negotiations in Sri Lanka, and in the field of litigation and alternate dispute resolution. He is a founder partner of Nitya Partners, where he heads the project finance and dispute resolution division of the firm. He, like Ms. Bari, also started his practice in the Attorney General's department, where he served as a state counsel from 1987 to 1986, before he formed the Nitya Partners. I believe he's also one of the two President's Counsels in Sri Lanka at the moment who heads a law firm or a structure of that sort. Mr. D'Souza has been involved in advising, negotiating, structuring major infrastructure, or probably most of the major infrastructure projects in Sri Lanka, spanning a multitude of sectors, including electricity, telecommunication, petroleum, railway, ports, basically entire ambit of the construction or telecommunication, all the sectors that has an actual impact on economic growth in the country. He has advised structuring and implementing many public and private partnerships in Sri Lanka, and was also the legal advisor in several major privatization of state entities by the government of Sri Lanka. Mr. De Silva continues advising the government as well as the private sector and lending institutions and these kind of transactions to date. Since 2010, that is almost 16 years ago, Mr. De Silva has been consecutively ranked as a leading individual in the field of project and energy dispute resolution by the Legal 500 Asia and Pacific. And in 2010, he was induced to the Hall of Fame of Legal 500 in both of these practice areas. He has been ranked Band 1 by the Chambers and Partners and is endorsed as an elite practitioner by Asia Law in the field of dispute resolution. He is also listed as a highly regarded IFLR 1000 in the field of banking, energy, and infrastructure and project finance. Expert guides by Euromoney lists Mr. De Silva as one of the world's leading practitioners in project finance. He's also, again, right at home here, because he's a visiting lecturer in commercial law at Sri Lanka Law College and the Master of Laws program of University of Colombo. Mr. Chandaka De Silva, I've seen you as an arbitrator several times, but it's a pleasure to invite you today as a panelist. That was a very lengthy introduction, but I think the panel today deserved it. Okay, so discussion today is going to be about trade routes and the disruptions in trade routes. I am sure all of you have followed up on everything that is going on. But before that, Ms. Bari, Mr. Anaka De Silva, President's Council, and Dr. Prashant Gunaratna, it's a pleasure to have you on stage. Now, when we talk about trade routes, the first thing that comes to my mind and the disputes is what's happening in Iran and the supposed peace treaty that Donald Trump seems to enter with Iran every other day that keeps changing. I think on June 17th, they signed the Islamabad Memorandum, and a few days later, that also didn't work out so well. Now, when the trade routes are so troubled, first thing us as lawyers think about is how do we deal with these disputes? But it's more important for people who are actually who are caught in the middle of these disputes. The contractors, the cargo owners, and also the shipping lines. They are at the thickest of these disputes. I understand this is a very broad area of discussion, but I want to focus, at least on broadly, I want to discuss what this looks like. My first question is actually towards Dr. Prashant. In your opinion, now, all of these issues gets, at least we call it hardships or force majeure events or events of frustration or unforeseen events. How do you identify the situation in Hormuz Strait or the trade disputes arising out of a conflict of this nature? How do you think these disputes get characterized?
All right, Thank you very much for that mind-provoking and thought-provoking question, Mr. Mohandiramge. Isn't it? Let me start by asking you a question. Isn't it unreasonable for you to give the opportunity for the junior most attorney at law to commence the proceedings of the panel discussion? Well, it's a rhetorical question. You need not answer, but nonetheless, let me dissect your question. My approach to the question is going to be multi-pronged and multi-tiered answer. At the very inception, let me emphasize this. Whatever the struggle for international politics, power is the ultimate and the immediate aim of international politics. The struggle for international politics is universal actually, universal in both time and in space. And this is actually the reality. Whether it's Hans Morgenthau's interpretation of a power-hungry nation state, or whether it's Niccolo Machiavelli's caricature and the interpretation of the prince as an effeminist character who craves for power. Both the state, the nation state, as well as the individual, the prince, crave and look forward to acquire power. So this is the very phenomenon which has brought us to this august assembly. We have congregated here to discuss a very important and a vital topic: arbitration in troubled trade routes. This is, of course, undoubtedly a contemporary topic which is of utmost importance. As you clearly pointed out, there is an overlap between public international law and private international law in this particular topic. This is my personal perception. And as a lecturer of public international law, I immediately, as I witnessed the topic, the only case in public international law which crossed my mind was the Corfu Channel case. Those who have studied public international law is quite aware of this particular case. It clearly stipulates what the state responsibilities are. Now, in addition to that, let me also put this particular topic into perspective. It is estimated that roughly 50,000 ships engage in an annual international trade, which amounts to 90% of annual international trade, which grossly amounts roughly to about 18.5 trillion US dollars. So this is what we are talking about. This is the contemporary nature of the topic under discussion. And on top of that, I'm not quite certain, but most of the people contemplate that this is a recent phenomenon, but I disagree. You know, the crisis in the Hormuz Strait is not a recent phenomenon. I'm not quite certain whether some of you are in this August Assembly were born in the 1950s, when the British and the French troops parachuted into the Suez Canal, which triggered the frustration of international maritime contracts. I'm also quite cognizant of the fact that you are well aware of the fact that Saddam Hussein invaded Kuwait in the 1990s. And that, of course, sparked a flurry of activity in international maritime trade. Now, in addition to that, you might also take into consideration the effects of non-traditional security challenges. And for example, the Polar case, which is a landmark case in British common law history, is centered around or revolves around piracy in the Horn of Africa and in the Gulf of Aden. Now, the rise of terrorism, the ascent of piracy in the Horn of Africa and the Gulf of Aden have actually indirectly and directly adversely affected the performance of a contract. Now, in such a circumstance, what are the options which are available for a party? Now, it might be a ship owner, a vessel owner. It might also be a charterer or an individual who has an interest in the cargo. So once a contract is rendered to have considered or rendered to be unperformable or frustrated, the parties will undoubtedly resort to their contract, which encapsulates their ulterior motives through the clause of force majeure, war risk clauses, and in addition to that, safe port clauses. So these are some of the clauses which are expressly intimated in the contracts. And even arbitrators, when it comes to international arbitration, will specifically focus on those express provisions, because they are enthusiastic in tangible evidence in the form of documentation, especially the contract, which may substitute that concrete evidence. So the force majeure clause is of vital importance for parties to enforce their obligations in times of frustration or non-performance, and so on and so forth. And in addition to that, I might also want to stress stress on the paramount importance of the charter party contracts, charter party time clauses rather, and the Hague-Visby rules. Now, these are the driving factors, or determining factors rather, in international maritime agreements. Now, this is quite fascinating because at the very inception I mentioned some of the precedents which arbitrators might look into when determining the cases before them. Now, remember, hostilities between the parties began, if I'm not mistaken, at the beginning of February 2026. It is as a result of the Trump administration's transactional foreign policy, and as a result of Iran weaponizing the Hormuz trade. Majority of the contracts in international trade have frustrated. So the only option, one of the only primary options for the parties to resolve their disputes, which is of binding nature, would be arbitration. Of course, conciliation and settlements are non-binding, and that clearly explains as to why the parties will resort to arbitration. So once those parties go before arbitral tribunals, the arbitrators will be clearly influenced by the fact that, number one, there should be a contractual agreement. Number two, the contractual agreement must encapsulate the most pivotal clause, the force majeure clause. In absence of a force majeure clause, they might resort to the war risk clauses, and in addition to that, safe port clauses. Now, these are famously known as Hormuz clauses, might be influenced by the recent developments in the Middle East. But there are also other doctrines, English common law doctrines, which can be utilized not only by the arbitrators, but also by courts in common law countries. Because Sri Lanka being a common law country, I'm deriving that example from the British common law system. So the British had, the British courts found that the doctrine of frustration and the doctrine of reasonable deviation to be darlings of court procedure. So in such a backdrop, it is cogent for us to deduce the fact that both the arbitrators and courts might resort to Hormuz clauses on the one hand, and on the other hand, English common law doctrines to resolve those disputes. I hope I answered your question, and because it's kind of a complex kind of question.
Thank you, Dr. Gunaratne. Actually, yes, you did answer the broad reasoning behind my question. I just want to put the second part of my question a little bit more in context, because this is an opinion, it doesn't have to necessarily be, it's an opinion that you might have about the conflict. Now, since February, before the war started, roughly about 120 to 130 ships crossed the Hormuz Strait a day. And that's about 1/5 of the entirety of the world trade sort of took place over, I think, about 27% or 25% of the trade took place through this strait. Since then, now it's about less than 20 ships a day, and if in most of the cases, 0 ships a day, and trade has significantly dropped. Now, when the Suez Canal cases were decided in the UK back then, in 1950s, they considered it not to be an event of frustration because there are other trade routes available. This same idea exists right now because, for example, most of the VLCCs, very large crude oil carriers, are sort of routed through the Cape of Good Hope. These are just practical shipping routes. But shipping routes, other alternative shipping routes exist. But I think this is a much more severe problem in terms of how commercial parties look at it. In your opinion, do you think general theory of frustration sort of applies here? Or do you think contract clause has to be very specifically targeted towards the situation to sort of actually be able to sort of gain more beneficial relief towards contractual parties? This is an opinion. I understand it's a very complicated
No,
question.
it's not complicated at all. It's an excellent question. Now, I concur with your fact that parties will have to resort to alternative routes. Because if I'm not mistaken, the Huda, is it the Huda case? No, the Polar case. The Polar case, the vessel had to circumnavigate the African continent via the Cape of Good Hope, which took them extra 2 weeks. Well, that is, of course, one of the causes which frustrates a contract or delays the performance of contract. So on that particular point, I completely agree with you, and I acquiesce with you. With regard to the doctrine of frustration, I don't think it's an orthodox approach towards the resolution of disputes with regard to arbitration. But there are certain recent developments with regard to the adoption of the doctrine or the theory of frustration. Now, for example, if the courts or the arbitration tribunal digs deeper into the doctrine of frustration, that is in the absence of hormuz clauses, the parties will have to establish that frustration results as a failure of their ability to act in good faith. So the doctrine of uberima fides also makes unpardonable inroads into the doctrine of frustration. So in such a backdrop, the onus is on the parties to establish that they have acted in good faith, and as a consequence of that, they had to deviate from the original route. So a vessel which was destined to China from, we'll say, Dubai, could not use the Hormuz Strait, but an alternative was suggested by Saudi Arabia to use the Bab el Mandeb. Now, this is a completely hypothetical situation. Bab el Mandeb, which allows the ship to transgress through the Red Sea to the Gulf of Aden and then the Indian Ocean and then to China. So now, in such a backdrop, frustration there is also reasonably foreseeable. For instance, Houthis in Yemen, who are sponsored by Iran itself, may have vested interests in that sea line, in that international sea line of communication. So even that is going to be clogged at a particular instance. So if that is also going to be an option which cannot be utilized by the parties, the other option would be to circumnavigate Africa. So all of those options may boil down to the resolution of disputes before an arbitral panel where frustration has to be utilized. On top of that, I would like to mention one of the fundamental cases with regard to frustration, the Sea Angel case. Now, the British courts adopted the strictest possible view with regard to frustration. Now, this particular case is of paramount importance to Sri Lanka as well. Sri Lanka is considered to be the hub of the Indian Ocean, strategic entrepot, which of course is situated at the very heart of international sea lines of communication. And Sri Lanka also encountered a similar incident with regard to the Express Pearl. Now, this is with regard to Pakistan, where an oil tanker met an unfortunate incident at the Karachi port, and the Pakistani authorities had to invite the Sea Angel to clean up the mess. But at the end of the day, the Pakistani authorities did not allow the vessel to leave because the contract had been frustrated. So there, the British courts had to strictly apply the doctrine of frustration and determine that the Pakistani authorities were acting in par with the agreement. So not only frustration, in addition to that, there are other options. For example, ASBA tank voyage clauses. convo time clauses, voyage and charter party time clauses, charter party voyage clauses. So these also come into play when it comes to arbitration. But you might also comprehend the fact that there is an interplay between the common law doctrines as well as the Hormuz clauses. But I think I will address those points towards the conclusion of any of the questions if you.
Thank you, Dr. Gunaratna. I think that was very insightful. I think if I was a law student back seated there, I think there will be a lot of notes I'll be taking. But unfortunately, fortunately, I have the pleasure of being on this side of the panel for a change. Dr. Gunaratna, now we spoke a lot about theory and how frustration, impossibility, these clauses are interpreted. I'm going to move to a different direction now when I come to you, Ms. Bari. I want to look at a little bit more of the practical experience on the ground, because while theory is important for lawyers, what's more important to the people on the ground is what are the relief they have immediately when the situation on the ground changes so often. The situation has changed several times from February, from 17th of June, even now. In your opinion, Ms. Bari, where the arbitration, of course, most of these agreements or shipping agreements will contain certain arbitration clauses. But in your opinion, if you want immediate relief, because most of the time you will need immediate relief when you're faced with a dispute that sort of changes so often. When you need immediate relief, where do you think the party should go to? Should it be the national courts? Should it be a different form of arbitration, for example, expedited arbitration proceedings, or should it be the normal arbitration tribunal?
Okay. First of all, I have to thank the Victor's Moot organizers for inviting me here. Thank you very much, and thank you for your question. Yes, with regard to your question, I would say one has to first consider so your question relates to whether one has to resort to arbitration or go to courts for immediate interim relief, right? So one has to first consider the terms of the contract. And in the terms of the contract, if you have an arbitration clause, clearly you have to go for arbitration because the courts will not entertain it. But when it comes to interim relief, you have to first analyze what the dispute is. If the dispute relates to in the realm of admiralty, then you have quick access because you can commence an action in rem in the Commercial High Court. So in that situation, our Admiralty Jurisdiction Act provides for jurisdiction in the Commercial High Court, and there are certain disputes if you come within section 3 or so, I can't remember the exact section, but if you fall within the provisions of the Admiralty Act, then you can invoke the jurisdiction in rem and seek to arrest the ship for interim relief. So if it is a maritime claim and you have a claim against a ship, then that would possibly be the quickest relief that you can get. And the Sri Lankan courts, the Commercial High Court is quite adept at adjudicating admiralty disputes. So that would be one of the options with regard to interim relief. The next option, of course, is to see what your clauses are and to see whether in terms of your contract, you have subscribed to an institution that provides for emergency arbitration. So this is something that is new. Emergency arbitrations are available if you have subscribed to a contract where you have either SIAC arbitration, ICC, and such other international arbitration centers. So if you take, for instance, SIAC arbitration, there is a process where you can seek relief within 24 hours. You make that application virtually ex parte. Even though they don't call it ex parte, you don't have to give notice to the other side. You make that application and then seek immediate relief from an emergency arbitrator. If the chairman of the SIAC center considers it a suitable dispute, it's submitted to the emergency arbitrator, and if the emergency arbitrator decides that there is relief to be granted, then short relief for a short duration of time. For 14 days, you are granted that relief, and thereafter notice is given to the other side. So that is another option. And of course, then the other option is whether you can go to court. Even though you would have an arbitration clause, and even though in terms of our law, an arbitration clause actually precludes you from going to court, when it comes to interim relief, the case law is such that you can seek interim relief in court. So even if you have a formidable arbitration clause which watertight arbitration provisions, with regard to interim relief, you might still face the fetter of not being able to enforce it in the short term. And therefore, it might still be prudent to go to the commercial high court, or to the high court rather, to obtain your interim relief. Because in a situation where if it doesn't fall within the jurisdiction of a REM action, where you invoke the admiralty jurisdiction, you might have to invoke the jurisdiction of the commercial high court to seek either interim injunction, some form of Mareva injunction to preserve the goods. If your goods are perishable goods and they are in mid-sea, you might want to have the goods preserved. You might want to have some form of an Anton-Pillar order where you want to gather evidence as to what is happening. So with regard to all of that, ultimately, however robust the arbitration procedure is with regard to the final dispute resolution, to answer your question, I think ultimately the overarching the safety net for in any dispute, regardless of whether the dispute relates to maritime claims or any other claim, the safety net would be the court for urgent relief, where you can actually have the force of being able to enforce it in the short term.
That makes sense. Now, of course, from the kind of reasoning that I'm following from your thought process, courts are preferable because the reliefs are enforceable. Now, I want to actually discuss enforceability a little bit, but before that, in a dispute of this nature, because most of it, as you said, if it's if it's within 24 hours, essentially it's ex parte, and because of the nature of, for example, the situation in Hormuz Strait or even any conflicts on, most likely than not, one of the parties might not have access to counsel because they can't retail counsel from the seat you are in right now, or the bank accounts might be frozen because of sanctions. In that sort of a situation, from a practical standpoint, if it is an arbitral tribunal, so what sort of considerations do you think as a tribunal you should think about? Because in practice, these are very real things that happens right now. Or and how should you think about interim reliefs in that kind of a context? This, of course, applies to courts as well. The consideration that goes beyond, for example, is this interim relief justified? More so, can the other party actually challenge it or actually even defend themselves if I grant this interim relief? That is before we come to enforcement, I feel.
Yes, before you come to enforcement, now your question is focused on what an arbitrator, what considerations the arbitrator should adopt when he is considering the application for interim relief, particularly in the context of an emergency application. So in my view, I think the consideration that the arbitrator applies will not change drastically simply because it is an ex parte application for interim relief. Even in that situation, even more so because it's an ex parte application, I think the arbitrators will adopt an equally rigorous approach that they would even if there was the other party was present. So they would look into whether there's a prima facie case, first and foremost, like in any interim relief application. Then the other one, whether there is irreparable loss. The famous considerations that even the court adopts, irreparable loss. Then, of course, the matter of urgency. What is different here would be the issue of urgency. They will look at, I think, the case law, particularly in SIAC cases, they have looked at whether the issue is urgent. So, to that extent, it might differ from run-of-the-mill um, interim relief application because of the fact that an emergency arbitrator is being called on to make a decision. The issue of urgency is perhaps what might make it distinct from a regular interim relief application, because the matter of urgency has also been looked into. And of course, the proportionality of the measures that have been the emergency arbitrator is being asked to implement. So to answer your question then, I think it will be a conventional analysis with regard to interim relief. But having said that, the matter of urgency and why it is urgent would be an extra consideration that the arbitrator will perhaps look at when determining this as to whether a short ex parte 14-day order should be made.
Thank you so much, Ms. Bari. It's always interesting. Now, we talk about all this theory, but in fact, practice, when it all comes down, you always go back to basics, especially with basic things that we want to get done. Now, the final question I want to ask is about sort of like the Sri Lankan context. Do you think if this dispute actually occurs somewhere in Sri Lanka, do you think the Sri Lankan court system and the current arbitration institutional framework actually supports this kind of emergency interim orders or emergency arbitrators? Does our law allow it, and does the sort of institutional framework sort of allow for it?
As far as our law goes, Arbitration Act per se goes, we haven't evolved into or we haven't developed a system that provides for an emergency arbitrator, for the appointment of emergency arbitrators. Because the conventional method of arbitration would be that you have to give notice of arbitration, and then both parties have to agree on appointing of the arbitrator, and that entire process will have to be followed. And thereafter, once there is an arbitral panel in place, an interim relief can be granted by that arbitrator. But no, we do not contemplate, our law doesn't contemplate a situation where an emergency arbitrator is appointed. I'm not sure whether the institutions, I think I can ask Hemamali whether they have developed emergency arbitrators. The answer seems to be ICLP has? ICLP, I'm told, has it. But again, it would depend on, even in Sri Lanka, it will depend on your contract. So if you have entered into a contract with, say, ICC rules, or if you are entered into a contract with which incorporates the SIAC rules, then inherent in that would be the provision for emergency arbitrations. So even if you haven't so even if your arbitration is based in Sri Lanka, you can invoke your contractual provisions to have the emergency arbitration provisions invoked, and then the Sri Lankan law, the Arbitration Act will then give the necessary support if it is there in the contract. If it is not there in the contract, of course, then you are basically at the mercy of courts, and then you will have to go to court to get your interim relief.
Thank you so much, Ms. Bari. It's always, I think, the best kind of insights that law students, of course, can get is practical insights. Because you can read all the theory in the world, but nothing will really prepare you to what you actually do in practice. Now, that being said, I'll now move to my third panelist. Thank you so much for your input, Ms. Bari. Mr. De Silva, now, my question to you is probably one of the most important questions that we ask on a daily basis in any other arbitration, but I think more important in a context where there is so much of lack of clarity regarding whether the awards and court orders can actually be enforced. Because in a situation where sanctions exist, where if, for example, Iran refuses to enforce awards of other countries and vice versa, how likely are these interim orders that Ms. Bari spoke about, and in general, awards in general, likely to be enforced in this kind of a context? Because, for example, in Russian conflict, there are awards given for more than 40 billion in the last 2 years, but none of those awards have actually been enforced in a proper jurisdiction, at least to my knowledge for now. How likely is enforcement in this kind of a conflict right now? And I also want your mind to be looked into sort of what we can do afterwards. But first on how likely is enforcement?
Minul, can I add to something that Dr.
Of course.
Gunaratna said and then carry on? You see, first of all, before I answer the question, I would like to add something to what Dr. Gunaratna said. Now, if you look at the Suez Canal cases, common law was what applied at that time, and basically three principles emerged, at least three principles emerged. One, if you have an alternate method of performance, there is no frustration. Two, if it is more expensive, there is no frustration. Merely because the contract became harder, there is no frustration. That's one aspect that came. That's why people had to go around the Cape of Good Hope and still the agreement was valid. The other problem that arose under the common law was the consequence of frustration. Frustration was an event which discharged the contract. So therefore, the contract ended, and the loss light where it fell. That is the common law, English common law at least. So that is not a solution to many of the contracts. That is the last position that you want. So as a result of that, in the shorter period thereafter, there came a situation where people tried to address this by having very elaborate provisions in their contracts, included in relation to how frustration is dealt with. And you call them force majeure clauses. And if you look at them, it basically says that if your performance is made difficult, the contract can be terminated perhaps in the future, but not immediately get terminated. Then all kinds of provisions and financial consequences were included into them. So in today's modern context, you find that it is very, very elaborate force majeure clauses are contained in those clauses. Today, even a bigger trend comes. For instance, what happens if the contract really becomes expensive? Right? Now, we had a situation like that in 2021, 2022, where performance was completely different to what was contemplated. So today, you have another set of clauses which are coming in, which are called hardship clauses. If the contract becomes harder, if it becomes more difficult, if it becomes more expensive, more different to what you contemplated, what happens? So you have force majeure clauses and hardship clauses coming. So those become very important when you negotiate contracts, particularly when you negotiate long-term contracts. So now I will come to the question that you asked about enforcement. Now, enforcement, essentially the question is like from where Shahida ended. Once you get an order, what happens? Now, supposing it is in Sri Lanka, I think the relevant section for you to look at is Section 13 of the Arbitration Act. It talks about, if my recollection is correct, it talks about an enforcement of interim orders. Now, orders of this nature, emergency arbitration orders that are given, essentially are in the form of interim orders. But the shortcoming in that act is that there is no procedure set out as to how you're going to enforce it. So what are you going to do? Right? So in that context, essentially the question that will arise is that there will be an objection to the procedure that is going to be taken up. But the conservative approach that may be taken is, well, we have enforcement provisions which are there in the Section 30s, and there is a process which is set down. Obviously, that process, if it is good for formal enforcement or final enforcement, it should be good for this as well. But then, unfortunately, we haven't really had any authoritative opinion coming out of the Supreme Court in relation to that as yet. But I believe that would be the conservative approach to be taken. So in that context, you may have to apply those provisions itself. Now, then the problem arises as to whether an order which is made in that manner ex parte in an arbitration is against public policy or is against natural justice not being followed, and therefore can it be objected to. And you would definitely see objections of that nature coming up if there is an enforcement application made. So we need to be aware of those, and we need to be ready to meet those. It is not as if you can't meet them. After all, if you did agree to a procedure and that was what you have in the procedure, then you have agreed to it. And in that context, when you get an order of that nature and it is going to be enforced, you should not be able to object to that. But those are matters to be decided, and unfortunately, our jurisprudence has not matured to that level on arbitrations yet. But of course, the simple answer is there is an update to the Arbitration Act coming. And I believe these matters are being dealt with in that. So in the short term, maybe in the next couple of years, we will have a new act where there are answers to these aspects as well.
Thank you so much, Dr. Zilla. Now, I actually want to sort of visit the initial part of the discussion also. Now, should both of these areas, one is you initially said there are enough and more sort of dovetailed clauses now being included, especially after the COVID force majeure events, that sort of specifically addresses these issues. And then you said interim orders are, of course, dealt by, mostly enforced by courts, so the procedure might be a little bit murky, but the procedure exists. Do you think commercial parties, both in terms of addressing the substantive elements of force majeure clauses right now, and in terms of procedure, are doing enough to sort of include all of these areas of question issues and deal with them in the contracts? And are those contracts generally enforced, at least not, even if it's not in Sri Lanka, are these contracts generally enforced elsewhere in the world, in your opinion?
Okay, let me give you a sort of a two-pronged answer. I've negotiated many infrastructure contracts, which are large contracts, long-term contracts. Some of them have ended, right? There were some contracts that I negotiated in 1995, 25 years, they're over, right? And there were no disputes. There were provisions of this nature, very, very, very complex provisions, which were included in them. And the reason why there were no disputes was because the contract was clear. So if your contract is clear, the possibilities of dispute are less. The contract provides what you need to do in a dispute, in a force majeure situation, what force majeure is, what happens in that context. You deal with that according to that, then there is no dispute. Dispute arises only if you don't comply with it. So in many of these large infrastructure projects, although there are very complex force majeure provisions, they work because they have been negotiated. And a lot of time is spent in negotiating those provisions. So that is one aspect of it. The second aspect is, very often in the more simpler commercial contracts, those matters are not paid enough attention. So as a result of that, I mean, you might copy and paste a provision from somewhere because it is a force majeure clause, and you don't really pay attention to what you are doing. See, force majeure clause is like, if I may explain it, a last will, right? It has no application until the event crystallizes on you. A last will has effect when you die. Similarly, a force majeure clause has effect when the difficult situation hits you. Otherwise, you won't even look at it. So therefore, you must pay attention to the fact that, look, if this difficult situation arises, what does the contract provide for? So if you haven't addressed that, what is the situation, what is the remedy I require because of the problem that I will face? So if you don't go through that sequence, then your force majeure clause will not work for you. So you might have a force majeure clause which might actually complicate the issues that you have rather than settling those issues. So that is why it is necessary when you're negotiating a clause to be very careful about how you negotiate. What are the situations you need to deal with? What are the complications or problems that I'm going to face or possibly face? And what remedy should I provide for? Those are the sequences you need to follow. Then you have a fairly reasonable clause which will work for you.
Thank you so much, Dr. Zilla. I think it's the simplicity of that answer made it so much easier, even though the actual negotiations and what goes into that discussion is so much more complex, and I don't think we have time for that. I want to move to the second phase of the discussion and sort of ask an open-ended question. I think it'll be better if this is sort of an advice to the sort of like the young potential counsel and sort of the transactional lawyers. This is open to the entire panel. I've sort of maybe gone a little off script here. In your opinion, first question is on drafting and thinking about the current status quo of where the contract happens, what sort of dispute exists. What would you think is the advice you would give across the board to sort of transactional lawyers when you enter into these kind of contracts? What are the considerations, in your opinion, they should look at? This is open for the entire panel.
The first advice I would give for any of the lawyers who would embark upon drafting a contract in relation to international trade would to concentrate fully on the controversial clauses of the contract, starting with the force majeure, the war risk clause, as well as the safeguard clauses. The parties, it is actually incumbent upon the parties to ensure the fact that those clauses are encapsulated in the contract. So, as I mentioned at the very inception in answering your first question, there had been precedents, and the contemporary context also reflects the fact that these conflicts are going to be prolonged for a particular time period. So it is reasonably foreseeable that these intervening factors may prolong for certain periods, and the parties are to expect that their contracts must engender all those clauses to circumvent all those hardships. So starting with the force majeure, as the learned President's Council pointed out, the courts as well as the arbitration panel will concentrate on that particular clause. Whether that particular clause includes a specific list of force majeure events. For example, if that specific clause does not encapsulate the ulterior motives of the parties, then of course that's the end of the story. Then the alternative option would be to resort to those doctrines. But those who wish to actually concentrate on drafting contracts, they might need to stress on those clauses, and also to stress on the payment of demurrage, the intelligence reports from certain states, insurers especially, prior to drafting of those contracts, so that they can foresee and enter into a more pragmatic and cogent contract before any dispute arises. The primary intention of drafting a contract is to avoid any dispute, and even if a dispute arises, the parties have the option of resolving it out of court in an efficacious manner. So in such a circumstance, it is of paramount importance for the parties to first draft the contract in a pragmatic and a cogent and a comprehensive manner.
Well, to answer your question, I think we have to first look at who we are advising. If, of course, we are advising the shipper or the person who's responsible for this process of navigation, then your perspective on the force majeure clauses, the frustration clauses will be different. On the other hand, if you're advising or drafting the contract from the perspective of the person who's actually the purchaser or the seller or the contracting counterparty, then your perspective will be different. So first of all, I don't think there's a ready-made answer as such, because it will all depend on whom you're advising and whose interest you're trying to cover. If you're negotiating with a shipper, then you wouldn't want a clause that is overly favorable to the shipper, whereas you would want a situation where if the frustration clause or the force majeure clause is overly tight, then because as the law now is, one has to prove impossibility. But if the force majeure clause is a looser clause, even in situations where the event doesn't give rise to an impossibility, then the shipper will be able to trigger that clause, and then if you are advising or you're appearing for the client who's actually, waiting for the goods to arrive on the other side, then the clause would have been drafted against you, and you're on a weaker footing. So therefore, I think, because if I may sort of allude to a personal experience about this impossibility situation, when I was in the department, we appeared for the Ceylon Petroleum Corporation over a dispute, and we took up the position that because of certain sanctions imposed on Sri Lanka, it was impossible to carry out the payments. But the opinion that we got, and even sort of the general pulse of the arbitrators, eventually we it didn't go beyond a particular point, but the sanctions per se didn't amount to impossibility, because there may have been other ways to route this payment. So similarly, even if your vessel is stuck in the port of Hormuz, it might not be conclusive that it is in fact impossible, and therefore there may be other routes that you can route your goods through. So therefore, in negotiating, one has to look at whose interest you are looking after, and thereafter come to middle ground with regard to the best course of action and the most equitable solution perhaps for all parties. So, but I think the clause that got little mention, therefore, in my view, I would say, you should also give attention to a change in circumstance clause, because that is the type of clause that is not as, it's not as final as a frustration clause or a force majeure clause. A change in circumstance clause will allow you to maintain your contractual relationship, but at the same time introduce some flexibility to move towards a more equitable solution in situations that do not trigger the impossibility situation.
Thank you so much, Ms. Bari. Mr. Zilla, do you wish to add something?
Yeah. Let me tell you a small story about what happened during a negotiation that I did. This was a long time ago, 1995, when I was negotiating a contract. We were negotiating the dispute resolution clause, right? And in that, the question was what happened when the award was given and enforcement of the award. I had an American lawyer negotiating against me. 30 years ago, I was also pretty young. That guy was also essentially my age, right? And he suddenly told me, look, this can't be enforced in Sri Lanka. I was a little shocked, but I said, why? Then he told me, look, your courts will be biased, right? Now, mind you, this was a power purchase agreement. A whole heap of lenders and investors are coming here and setting up a power plant, selling power to us, and we are paying them. That is the circumstance, right? So I told, okay, if that is your position, then your side, you have investors from Japan, Germany, UK, your lenders are from the US and from some other place, France, something like that. I don't want the contract enforceable in any of those places. Right? He said, okay. I said, okay, let's draft it. And we drafted it. It took about 10 minutes for us to finish that clause. And he was very happy. But essentially, what did he agree to? And what did he ask? See, who pays the money in that? Where would the breach be? We are buying. We are paying. The plant is going to be here. Their work is over once they set up the plant. If they don't set up the plant, I really am not concerned, because that's his money, right? So the chances are that we would have been in breach, right? And they would go to arbitration against us. They need to enforce the award against us. And what did he do? He prevented that award from being enforced in Sri Lanka. By agreeing to my requests, he prevented that award being enforced in any of the countries where we would normally have assets. And I was pretty happy, right? Now, why did that happen? That happened because that guy was very much interested in a particular standard, but was not concentrating on what the essential problem was that he was going to get a solution to, right? So when you are negotiating a contract, when you are drafting contracts, don't ever get entrenched in situations or arguments. Look at the issue. Look at what impact it has on you. Look at the solution that you want. And don't negotiate from entrenched positions. And those positions will change from contract to contract, situation to situation. Force majeure is similar. The force majeure clause in a port agreement is not going to be the same as in a purchase agreement. Right? It is going to be very difficult in a different in a shareholders agreement. So you have to look at the type of agreement that you're negotiating, and in that context, see what you're going to sort out. So whatever the clause you're negotiating, that is essentially the principle you must follow.
Thank you so much, Mr. Zilla. Now, one thing I wanted to highlight from this discussion is that while the dispute resolution part is important, while understanding sort of avenues that's available to you is important, it's probably equally and probably more important for you to get the start correct. That's why I wanted the advice to be on the transactional side. If you don't understand the context of your clauses, if you don't know the parties that you are properly advising, and if you sort of draft based on entrenched positions, that's basically what the panel is discussing, then at the start itself, your dispute is bad. So you need to set yourself up for a good dispute resolution if you actually want to sort of benefit from the process of dispute resolution that comes, as Mr. Zilla said, at the end, like a last will. So that's why you need to make sure that the drafting happens properly so you can benefit from it. Now, I understand Indivar is looking at me because I'm a little out of time. But for the benefit of the House, I'll open the House to maybe one question from the Assembly today. So you can ask a question from the panel. Indivar, I hope that's all right. Yeah, so we have time for one question. Is there anyone who wishes to ask a question from the panel? Maybe wake up a little bit from the evening session. Is there anyone from the law students who wish to ask questions, maybe from the invited teams that are here? Okay. Yeah, I think they were. That's probably correct. It's a wonderful opportunity for me to moderate this discussion because I think I learned more from this discussion than probably. I've genuinely learned a lot, not just about the law that apply, but also in practice what to look out for, especially in terms of, look, we learn about arbitration, we know it exists, but how to practically use it, and also the consideration you need to actually look for before you go ahead with arbitration. Of course, the context differ, disputes gets complicated, wars happen, but the basics of why arbitration exists, why you need to go to different forums or interim measures, why the transactional part of that dispute is so important. Like, these are things you'll only probably learn in practice when you've been through the mill, when you've gone through the disputes and understand where our parties went wrong. And I think that is what the panel added to the discussion today. And I don't think you can learn this from any sort of book you read. So thank you so much, Mr. Zilla, President's Council, Ms. Bari, and Dr. Gunratna for joining the panel discussion today. It's a wonderful opportunity for me, and I genuinely enjoyed it. Thank you so much. Ms. Indivari, thank you for having me.
Thank you to our esteemed panelists and our moderator for that interesting and illuminating discussion. I think that deserves another round of applause, ladies and gentlemen. Your insights this evening will without a doubt stay with every young budding lawyer present here today. We would like to invite Mr. R. Shehansi Pereira on stage, Deputy Principal of Sri Lanka Law College, to hand over a token of appreciation to our panelists as a gesture of gratitude. Indivari will assist the Deputy Principal. Thank you very much to the panelists, the moderator, and Mr. Pereira. Thank you. It is now my honor to invite the chief guest for this afternoon, for this evening rather, Honorable Parinder Ranasinghe Jr., President's Counsel, Attorney General of the Democratic Socialist Republic of Sri Lanka, to address the gathering.
Dr. Kanagiswaran, President's Counsel, the Secretary of the Bar Association, the Principal and the former Principal of Law College, distinguished guests, members of the organizing committee, participants, ladies and gentlemen, a very good evening to you. And I'm delighted to be here today. And it's a great pleasure to be with you this evening as a chief guest at the closing ceremony of the 9th Victor's Moot. It is formerly known as the Dr. H.V. Pereira QC Memorial International Moot Competition. Sri Lanka Law College has served as the legal profession of this country for more than 150 years. It is not only a place where law is taught, but where generations of lawyers have learned the discipline, responsibility, and practical skills that being an attorney at law demands. The Victor's Moot is one such example of that practical training in action. The competition began as a moot competition, as a national moot competition in the year 2017, and later became an international competition carrying the name of the late Herbert Victor Pereira, Queen's Counsel. Today, it is Sri Lanka's first international commercial arbitration moot, bringing together students from Singapore to South Africa, India to Uganda, and several countries in between. No small achievement for the Sri Lanka Law College Moot Society. My congratulations to you. For those less familiar with this exercise, a moot is a simulated court or an arbitral hearing. Students are given a legal problem, then they study facts, identify issues, research the law, prepare written submissions, and then present oral arguments before a panel, which questions them closely and tests whether arguments truly hold up against the law and the facts. Mooting is simply not public speaking, and it's certainly not a debate that usually goes to the loudest and the most confident voice in the room. It is persuasive legal advocacy. A good mooter has to know the record, understand authorities, apply the law to the facts, and help reach conclusions they are arguing for. This demands several skill sets. A mooter must speak clearly, listen carefully, and answer the question that actually asked, not the one they hope for. A prepared speech is never enough on its own. When difficult question is posed, a mooter has to step outside the script, think on their feet, and respond accurately. Mooting is also teaches something less obvious: professional honesty, judgment, and time management. No lawyer knows the answer to every question. When you don't, it is far better to say so respectfully than offer careless or misleading answer. A panel that spent time on one issue forces you to decide quickly what is essential that can be shortened and what has to be left out altogether. Nor is it enough simply repeat what a case or textbook says. The real task is to explain why legal principle applies to a particular facts before the tribunal. In that sense, mooting turns legal knowledge into legal reasoning. All this is very close to real legal practice. Distinguished guests, these are skills the legal professionals need more than ever today. Lawyers now work across borders, and commercial transactions can involve parties, goods, technology, and obligations spread across several jurisdictions at once. New questions keep arising from artificial intelligence, digital trade, intellectual property, climate change, sanctions, shipping risk, and global supply chains. A lawyer has to be able to research unfamiliar territory, understand different legal systems, and communicate a solution clearly. International commercial arbitration is a particularly good field for this kind of training. It is one of the most widely used methods of resolving international commercial disputes, allowing parties from different countries to have their disputes heard by a neutral tribunal under agreed rules. This year's competition, conducted under ICC arbitration rules, gives students a chance to engage with a process many of them will meet in real practice. The subject of today's panel discussion, arbitration in troubled routes, is a good illustration of why this field matters. It relates to a live and a contemporary topic that allows us to deep dive into a very real issue the world has to contend with. The Strait of Hormuz is one of the world's most important maritime choke points, and a large tonnage of the world's seaborne oil and gas pass through it. Any serious disruption that reaches far beyond the states bordering the strait. It can push up freight charges, insurance premiums, fuel prices, and delivery times, with consequences for developed and developing countries, economies like Sri Lanka included. In short, the de facto closure of Hormuz has created acute disruption across the world's energy and shipping markets. The difficulty lies in the gulf between the legal position and the practical reality. The Strait of Hormuz remains an international strait. And international law, transit passage through it is non-suspendable even at times of conflict. But the reality is so the contrary. The threat of attacks makes the route unsafe. A legal right to pass offers little comfort for ship owners, charterers, and cargo owners, who may have to keep the vessel idle or to take far longer routes at considerable cost. These conditions raise hard contractual questions. Has the contract been frustrated? Does force majeure or war risk clauses apply? Was a deviation reasonable? And the nominated port still safe? Who bears the cost of delay, rerouting, higher insurance, or non-delivery? Thus, in conjunction with this, a likely wave of contractual notifications, preliminary arbitral referrals, is bound to underscore the commercial sensitivity and the legal intricacy of this matter for ship owners, charterers, cargo interests, and the like. This is where arbitration comes into focus. It offers a structured and binding process of resolving disputes of this kind. But good dispute resolution really begins before any dispute arises. Lawyers must draft contracts with foresight, identify and allocate risk clearly, and building workable procedures for resolving disagreements. My congratulations to Mr. Chanaka De Silva, President's Counsel, Ms. Shahida Bari, and Dr. Peshan Gurunatha, State Counsel, on a timely and thoughtful discussion. And all three of them have been, one way or the other, have been associated with me in my department, Attorney General's department, so it's very special for me. Unfortunately, during my time at Law College, Moot Society was defunct. It is only now I realize the real value of these endeavors. It is never only about winning, but the whole experience. It trains careful preparation, disciplined thought, confidence, resilience, and respect for divergent views. To every participant here, I want to say this: your success cannot be measured only by the result announced tonight. Some of you made it through to the preliminary rounds, the quarterfinals, and semifinals, and 2 teams have reached the finals. But every one of you who researched the problem, prepared a memorial, stood before a panel, and answered hard questions have gained something that will last. You have also learned to work as a team, to divide the load, challenge each other's arguments, take criticism, and sharpen shared piece of work. Importantly, you have made connections with students, academics, and practitioners from other countries. Hold on to these friendships and professional relationships. The people you have met here today may well turn out to be your colleagues, your opponents, your advisors, and your collaborators in the years ahead. This evening belongs above all to the participants, and I congratulate the winning team in advance, and I congratulate every team that took part, and I hope you will keep mooting, keep learning, and keep building courage to stand up, think clearly, and speak with purpose. In conclusion, distinguished guests, let me add that future of this profession will belong to lawyers who know their law, hold their ethics, adapt readily, think beyond borders, and most important, can explain themselves clearly. Competition like the Victor's Moot help build exactly that. I wish the Moot Society, who put together this monumental event, every success in the years ahead, and wish you all the very best in your studies and the careers lie ahead of you. Thank you very much. And listening to, I was privy to the conversation about the Hormuz. Come to think of it, the closure of Hormuz is not a bad thing after all for us lawyers. So anyway, thank you very much. Okay.
So, we thank you most sincerely for your presence and for the words that will long be remembered by everyone in this hall. An event of this nature is always uplifted by the presence of our esteemed guests. We would now like to invite our principal of Sri Lanka Law College, Mr. Prasanthalal D. Alvis, President's Counsel, to hand over a token of appreciation to our chief guest, Honorable Parinder Ranasinghe Jr., President's Counsel, Attorney General of the Democratic Socialist Republic of Sri Lanka. Thank you very much, sir. We request the principal to stay back on stage. Thank you, sir. We would now like to invite Dr. K. Kanagiswaran, President's Counsel, to receive his token of appreciation. Thank you very much, Dr. Kanageshwaran. Thank you very much, Principal, sir. Thank you. This year's final round of the 9th Victor's Moot was contested at the very highest level. And we now invite Mr. Chanaka De Silva, President's Council, a member of the panel of judges who presided over the final rather, to share their reflections. Over to you, Mr. De Silva.
At the outset, let me thank the Moot Society for inviting me here this evening, as well as to preside over the final sessions which were held. And congratulations for putting together this marvelous event. This evening, as well as the sessions that were held. When I looked at the Moot problem, it was an excellent problem. It had enough of meat in the problem for all parties to argue it out very well. And my comments, of course, will be restricted to the final round that was held. And we had a private conversation with the two parties who participated in that. And I will repeat the comments that I made at that point. The presentations were excellent. It was beyond expectation. But at the same time, we did expect them to be of very high quality, because the parties who come there generally get prepared for that high quality. And this was the final round, and I must say it was beyond what we expected. So congratulations to the two parties in relation to that. But what impressed me and the whole panel today is how they reacted to the questions that were asked. The tribunal consisted of 3 practitioners, and in the course of our listening to the submissions being made, we asked questions that probably a normal tribunal would not ask in a normal arbitration. They were very pointed, they were very concise and precise based on the facts which were there. But the reaction and the responses that we received were exceptional. Frankly, very frankly speaking, I don't know whether I would have been able to come up with the responses that the participants gave today. So congratulations. That was really heartening to see coming from the participants at the final round. So therefore, you will then realize that we had an excellent final round today. And it is pursuant to that we have selected the winners. And there were 4 participants, and all 4 participants were equally good. However, there was a very detailed marking scheme that was given to us, and we analyzed the positions very carefully. There are slight differences between the participants, and it is those slight differences that actually resulted in the results that you're going to hear in a short while. So don't get disheartened because you did not achieve the highest position. You did extremely well, like I told you. So therefore, whether you go away with an award or a prize today, or whether you become runner-up, it really doesn't make a difference. Both the teams did extremely well. All participants did extremely well. And my wishes to everyone who participated in their careers, that they're going to have ahead. And I think this experience would stand you in good stead for that. Keep doing this, and I'm sure you will be excellent lawyers when the time comes. All the best to all of you.
Thank you very much, sir. I would like to invite Mr. Vinura Gamage and Ms. Indivari De Silva on stage to hand over a token of appreciation to the judges of our final round, Mr. Chanaka De Silva, President's Council. Thank you once again, sir. We would also like to thank, in absentia, Mr. Chandakajaya Sundara, President's Council, and Dr. Asanga Gunawansa, President's Council. And now, ladies and gentlemen, the moment so many in this room have been waiting for, the award ceremony of the 9th Victor's Moot. To every team present here today, regardless of the outcome that follows, you have already achieved something remarkable simply by standing on this prestigious stage. And give yourselves a round of applause for that. To distribute the first set of awards, we would like to respectfully invite Mr. R. Shehansi Pereira, Deputy Principal of Sri Lanka Law College, assisted by Ms. Indivari De Silva, Chairperson of the 9th Victor's Moot. We start off with the awards for the plate semi-finalists. The first plate semi-finalist of the 9th Victor's Moot, congratulations to Royal Institute Campus, Sri Lanka. The team consists of Mr. Nadu Nirmala, Ms. Suhansa Dodangora, Ms. Husna Imtiaz, and Ms. Yusuf Sherifni. Plate semi-finalist, Royal Institute Campus. The second plate semi-finalist of the 9th Victor's Moot, the School of Law, Christ University, Bangalore, India. The team consists of Ms. Varalika Singh, Ms. Sakshi Buttar, Ms. Tirna Pal, and Ms. Sarah D'Souza. Plate semi-finalists, the School of Law, Christ University, Bangalore, India. We now move to the award for the plate finalist. Plate finalist of the 9th Victor's Moot, Stellenbosch University, South Africa. The team represented by Yusuf Achilles, Tiffany Caesar, and Matthew Spire. Your plate finalists, Stellenbosch University, South Africa. Thank you, Mr. Pereira. To distribute the next set of awards, we cordially invite Mr. Upul Jayasuriya, President's Counsel, who will be accompanied by the Head of Finance, Mr. Abdullah Siddiq. The most prestigious award in the plate round. The Mr. Eardley Russell Pereira PC Memorial Award for the plate round winner, O.P. Jindal Global Law School, India. Team represented by Yash Rao, Vidisha, Krish Agarwal, and Tanvi Narula. Your plate winners of the 9th Victor's Moot, O.P. Jindal Global Law School. Unfortunately, Mr. Jayasuriya, I have to trouble you for a little while longer, and Abdullah Siddiq as well on stage for the next 2 awards. Thank you very much, sir. The next award, the runner-up for the Best Memorandum for Respondent. The National Law Institute University, Bhopal, India. The next award, the runner-up for Best Memorandum for Claimant. The University of Colombo, Sri Lanka. Fortunately, both teams are not present today. Thank you very much, sir. To distribute the next set of awards, we cordially invite Mr. Prasantalal Dialvis, President's Counsel, Principal of Sri Lanka Law College, who will be accompanied by the President of the Moot Society, Mr. Vinura Gamage. The late Justice Dr. A.R.B. Amarasinghe Memorial Award for the Best Memorandum for Claimant. Rajiv Gandhi National University of Law, Patiala, India. We move on to the next award. The late Justice Dr. A.R.B. Amarasinghe Memorial Award for the Best Memorandum for Respondent. Damodaram Sanjeevaya National Law University, Visakhapatnam, India. The team consists of Ms. Divya, Ms. Garvita Garg, Mr. Ravi Sukeshan, and Mr. Siddhi Vinayak. Your winners of the Best Memorandum for Respondent. We move on to the next set of awards. Honorable mentions to 3 of the best oralists. The first of which, honorable mention, goes to Miss Tiffany Caesar, Stellenbosch University, South Africa. We would like to invite a representative of the university to come up on stage to receive the award. Next honorable mention goes to Mr. Siddhi Vinayak, Damodaram Sanjeevaya National Law University, Visakhapatnam, India. The final honorable mention for the Best Oralist Award goes to Ms. Suhansa Dodangoda from Royal Institute campus. We move on to the next award. The runner-up for the Best Oralist Award. Representing the National University of Singapore, Miss Shanice Ong. Congratulations to the winners. Thank you very much, sir. To distribute the next set of awards, we cordially invite Dr. K. Kanagiswaran, President's Council, onto the stage, who will be assisted by the Deputy Principal of Sri Lanka Law College, Mr. R. Shehansi Pereira. We move on to the awards for the semi-finalist of the 9th Victor's Moot. Congratulations to Apit Colombo University. The team consists of Ms. Prabhani Senanayaka, Ms. Nishela Mutugala, Ms. Amrudha Varshika Ravi, and Ms. Purna Nanakara. Ladies and gentlemen, presenting to you your semi-finalist, Apit Colombo University. Congratulations to the team. We move on to the next award. The second runner-up of the 9th Victor's Moot. Congratulations to Damodaram Sanjeevaya National Law University, Visakhapatnam, India. Team consists of Ms. Divya, Ms. Garvita Garg, Mr. Ravi Sukeshan, and Mr. Siddhi Vinayak. Ladies and gentlemen, your second runner-up of the 9th Victor's Moot, Damodaram Sanjeevaya National Law University. Congratulations to the winners. Thank you, Dr. Kanagiswaran. Thank you, Mr. Pereira. To distribute the most prestigious individual award, we cordially invite Mr. Nipuna Kasun Pereira, Marketing Manager, Corporate and Value-Added Products, Tokyo Cement Group, onto the stage. He will be assisted by the Head of Finance, Mr. Abdullah Siddiq. Ladies and gentlemen, the most prestigious individual award of the 9th Victor's Moot, the best oralist, representing the National University of Singapore, Mr. Varun Karthik. Ladies and gentlemen, give it up for the best oralist, Mr. Varun Karthik. Thank you very much, Mr. Pereira. To distribute the last set of awards, we respectfully invite our chief guest, Honorable Parinder Ranasinghe Jr., President's Council, Attorney General of the Democratic Socialist Republic of Sri Lanka, assisted by our principal, Mr. Prasantalal Dialvis, President's Council. After an intense finals, the best oralist of the final round, representing the National University of Singapore, Mr. Jared Goh. Ladies and gentlemen, please put your hands together for the best oralist of the finals, Mr. Jared Goh. Congratulations. Now we are down to the final two awards. After a hardly fought preliminary round, and a final round this weekend at Sri Lanka Law College, we have a winner for the 9th Victor's Moot. The winner of the 9th Victor's Moot, your champions. Congratulations to the National University of Singapore. The team is represented by Ms. Shanice Ong. Let's keep the applause going, ladies and gentlemen. Your champions for the 9th Victor's Moot. Mr. Varun Karthik. Mr. Jared Go. And Mr. Raymond Wong. Have the team together to receive their award. Ladies and gentlemen, give it up for the champions, the National University of Singapore. If I could request the Attorney General to remain on stage for the last award. Given away the award for the champion, but not to forget the team that made it to the finals. The runner-up of the 9th Victor's Moot, the Singapore Management University. Team is represented by Miss Iman Nabila, Miss Kimberly, Miss Isabel Teo Jening, and Miss Leong Mei Lin. Invite the team to receive their award. Ladies and gentlemen, the runner-up of the 9th Victor's Moot, the Singapore Management University. Thank you very much, sir. Congratulations to all our winners present here today, and to every team who competed with such distinction throughout this weekend and throughout the preliminary rounds. We thank you for your efforts. You are, each of you, a credit to your institutions and to the profession you are preparing to enter. As our evening draws to a close, we now invite Ms. Indivari De Silva, chairperson of the 9th Victor's Moot, to deliver the vote of thanks.
Good evening, distinguished invitees, the Chief Guest, the Honorable Attorney General of the Democratic Socialist Republic of Sri Lanka, Mr. Parinda Ranasinghe Jr., President's Council, the Guest of Honor, Dr. K. Kanagiswaran, President's Council, the Principal, the Deputy Principal of Sri Lanka Law College, and other distinguished guests, sponsors, esteemed arbitrators, valued participants, and organizers of the 9th Victors' Moot. It brings me great pleasure as the chairperson of the Victors' Moot 2026 to deliver the vote of thanks at the closing ceremony of the 9th edition of the H.V. Pereira Queen's Counsel Memorial International Moot Competition. The Victors' Moot is the first and only international arbitration moot in Sri Lanka. And it gives me and my committee great pride to have been given the opportunity to continue the great work that has been carried down over the past 8 editions. This year, we had the privilege of hosting 6 international teams in Sri Lanka, holding the 9th Victors' Moot in a hybrid format, with rounds being conducted physically after a lapse of 6 years. This competition would not have been possible without the invaluable support provided by the well-wishers and supporters of the Victors' Moot, whom we deeply appreciate. And I am honored to have the opportunity to extend my gratitude to these individuals and institutions. First and foremost, I would like to extend my immense gratitude to our chief guest, Honorable Parinda Ranasinghe Jr., President's Council, for gracing us with his presence and making this closing ceremony truly special. This is a global event, and by your esteemed presence, the closing ceremony of the 9th Victors' Moot brings inspiration to law students not only in Sri Lanka, but also across the globe. Thank you, sir. Next, I would like to extend our thanks to the guest of honor, Dr. K. Kanagiswaran, President's Council, who has always been a steadfast supporter of mooting at Sri Lanka Law College. A few years back, Sri Lanka Law College did not have a moot court for practical training sessions. However, with the generous contribution of Dr. Kanagiswaran, last year the Moot Society of Sri Lanka Law College was able to hold the 8th Victors' Moot online in our very own moot court. And this year, in 2026, dear sir, your generosity has allowed not only students from Sri Lanka, but across the globe to have rounds of the 9th Victors' Moot to take place inside our very own moot court. Thank you, sir. Next, I would like to extend our thanks to the principal of Sri Lanka Law College, Mr. Prasantalal Dialvis, President's Council, for his unwavering support of the Victors' Moot and the Moot Society of Sri Lanka Law College, as well as being a supportive pillar and ensuring the smooth run of college facilities for the tournament across these last 2 years. We are truly grateful, sir, for everything you have done for us. Thank you. I would also like to thank the Deputy Principal of Sri Lanka Law College, Mr. R. Shehan C. Pereira, for your constant guidance in all things to do with the Victors' Moot. Your office has always been open to us for any concern, and we are truly grateful for everything that you have done for us, sir. Thank you so much. I would also like to thank our esteemed panel of arbitrators for the final round of the Victors' Moot 2026, Mr. Chanaka De Silva, President's Council, Mr. Chandaka Jayasundara, President's Council, Dr. Asanga Gunavansa, President's Council, for providing their invaluable time to assist us to enhance the capabilities of our participants, thanks to their wealth of knowledge gained through decades of service to the legal profession in Sri Lanka. I thank our esteemed panelists, Mr. Chanaka De Silva, President's Council, Dr. Peshan Gunaratna, and Ms. Shahida Bari, attorney at law, and our insightful moderator, Mr. Minul Muhandiramge, for providing all in attendance here with a wealth of information and renewed perspective on arbitration in troubled trade routes. I would like to acknowledge Mr. Chanaka, President's Counsel, who went above and beyond, being both a final round arbitrator and a panelist at the closing ceremony of the 9th Victors Moot. So we are extremely grateful for everything that you have done for us this year and over the years. Thank you so much. I would also like to thank Ms. Indira Samarasinghe, President's Counsel, former Principal of Sri Lanka Law College, Mr. Upul Jayasuriya, President's Counsel, Mr. Harsha Amarasekara, President's Counsel, Mr. Mohammad Adamali, President's Counsel, for their continuous and generous support in ensuring the functioning of the 9th Victors Moot. I would also like to extend my gratitude to the President of the Bar Association of Sri Lanka, Mr. Rajiv Amarasuriya, and the Secretary of the Bar Association of Sri Lanka, Mr. Nalin De Silva, who is here with us today, for honoring us throughout this entire procedure. This year, the Victors Moot was capable of hosting the most number of rounds in its history. And this would not have ever been possible if it wasn't for the arbitrators who graciously devoted their time and effort from their extremely busy schedules to be there with us throughout the entire duration of the competition. I would like to thank the arbitrators of the bronze final rounds, the plate final rounds, the semi-final rounds, the plate semi-final rounds, quarter-final rounds, and 2 preliminary rounds of the 9th Victors Moot for your invaluable support in making this competition a success. I extend an immense gratitude also to our valued sponsors, whom this entire competition and this closing ceremony would not be possible. We would like to thank our bronze sponsor, Tokyo Cement, and the support of Mr. Nipuna Kasun Pereira, Marketing Manager, Corporate and Value-Added Products, for his immense support of our endeavors and ensuring the success of today's event. A special thank you also goes out to Ms. Melina Amarasinghe, who has been a continuous and constant support of and pillar of support and strength for the 9th Victors Moot and the Victors Moots previously. I also extend my immense gratitude to our sponsors, ICLP and FJNG Diserum, and all other sponsors for your invaluable contributions in making the 9th Victors Moot a success. I also take this moment to extend my sincerest gratitude to our valued participants. You give this tournament and this competition so much color, and without you, the true purpose of the 9th Victors Moot would not have ever been achieved. And for this, we are truly grateful. Especially to our quarterfinalist teams who are here with us today, our Singaporean teams, the Singapore Management University, the National University of Singapore, as well as our Indian teams, OP Jindal Global University, Damodaram Sanjeevaya National Law University, Visakhapatnam, School of Law, Christ, deemed to be University, Bangalore, our South African team, Stellenbosch University, and our 2 Sri Lankan teams, Apit Colombo University and Royal Institute Campus, for being with us and making this entire event very colorful and very interactive. And we want to give a special thank you to all of those teams who made the long journey from their respective countries to Sri Lanka. Thank you for having faith in us, in the Victors Moot, and we hope that your short stay in Sri Lanka has both been comfortable and enjoyable. We hope we made a lasting impression of Sri Lanka that encourages you to visit us again. I would like to extend my gratitude to the Moot Problem Drafting Committee, who made an absolutely fantastic Moot problem this year with extremely detailed case. And these individuals we will forever and immensely be grateful for providing support not only in drafting the Moot problem, but spending tireless nights marking our memorandums and in answering all clarifications from the participants, but also sometimes from a very confused organizing committee in the middle of the night. A heartfelt thank you also goes to the administrative staff of the Sri Lanka Law College, without whom this event would have only been a dream. Mr. Upul, Mr. Dylan, Mr. Madara, Ms. Chandupa, Mr. Akalanka, and all supporting staff who spent long hours in college with us, ensuring that the 9th Victor's Moot was a success. We truly appreciate everything that you have done for us over the countless years. I also extend a warm thank you to our swing team coach, Mr. Sahan Veeratunga, for taking time off his busy schedules to coach our swing team. A very, very big thank you goes to our Moot Society alumni, who are many in number and constant in support, namely Nimanga, Kavindu, Manul, Shakila, Anam, Desiree, Sayuni, Hemangi, Samudi, Yashwananthan, Tisuru, Uzma, Nilupuli, Reshman, Ruin, who have joined us here today, and all the other past executive committee members. A special mention goes to Mr. Sayuru Karyavasam, who was a vital part of ensuring the success of the 9th Victor's Moot. I would like to extend a special thank you as well to our very special compeer of the day, Abid Jamil, whose tireless effort ensured the smooth flow of this event. And now to my organizing committee, but most especially to the executive committee of the Moot Society of Sri Lanka Law College. The President, Mr. Vinura Gamage, Secretary, Ms. Ranmali Nanayakara, Vice President, Kiana Miriam Paldano. No words can ever express how thankful we are for everything you have done to make this event a success. I speak for the committee when I say thank you for everything, because this event would never have run as smoothly as it did if I didn't have you to lean on and to rely on throughout this entire tournament. We would also like to extend our thanks to the other committee members of the Moot Society of Sri Lanka Law College. Your constant support was the backbone of this entire event. We also have a small token of appreciation to be given to Mr. Vinura Gamage, Ms. Ranmali Nanayakara, and also Ms. Kiana Miriam. Thank you so much for everything that you have done for us over the past few months, in fact, to make sure that this is a success. Finally, and not last but not least, so to speak, I'd like to thank my organizing committee for their hard work and continued commitment in finally achieving the dreams we thought that we would not be able to achieve by actually having a physical competition after 6 years. Firstly, to my core team, Nuan, Sahan, Satish, Abdullah, and Menuka. I could never have thought of pulling this off without any of you. Your tireless and overly enthusiastic and especially jovial personalities are especially what made this entire thing far more easier for me to have done. I couldn't have done any of this without you. To my senior committee, each and every one of you have gone above and beyond your roles and ensured that it was easy for us, the core team, to make sure that every single participant was capable of doing their job, making sure that every small detail was achieved. And finally, to my junior committee, thank you for your extremely committed and excited perspectives. You make my life much easier, and you were the driving force behind the Victor's Moot this year. It clearly shows that you have so much promise, and we look forward to the Victor's Moot next year as well. Thank you, each and every one of you who are here today, and for all those who were not able to be here today as well. Your unwavering support and participation in making sure that the 9th Victor's Moot was a success. We are truly grateful, and we eagerly anticipate to see you, all of you, next year at the 10th Victor's Moot. Thank you very much.
I heard the principal and deputy principal say it, but I think the entire audience needs to know that there was one more person that was behind the 9th Victor's Moot. For us to be able to have a physical competition, there was someone who was right at the helm, and you just heard from her a few minutes ago or a few moments ago. Ladies and gentlemen, please put your hands together for our chairperson, Ms. Indivari De Silva. Thank you very much, ladies and gentlemen. Please rise for the national anthem of Sri Lanka.
Sri Lanka Mata, Ab Sri
Thank you very much, ladies and gentlemen. From myself, Abid Jamil, on behalf of the Moot Society of Sri Lanka Law College, we wish you safe travels, our friends who have joined us from overseas, and we look forward to welcoming you all once again next year to the 10th Victor's Moot. Hope you all have a wonderful evening. Good night.